a todos. En nombre de la International Chamber of Commerce México, les damos la más cordial bienvenida a nuestra sesión remota del Comité de Arbitraje de nuestra organización. Les recordamos que nuestras reuniones se rigen bajo el protocolo de competencia económica que se encuentra integrada en nuestra convocatoria. Con respecto a esta sesión, hemos enviado algunas recomendaciones, por lo que les pedimos mantener su micrófono en silencio. Al final de la exposición tendremos oportunidad de recibir sus preguntas por medio del chat de la aplicación o bien solicitando la palabra directamente. Les informo, por supuesto, que la exposición y dinámica será presentada por nuestra presidenta Gabriela Álvarez. Y sin más, le cedo el uso de la voz a nuestra presidenta de nuestro Comité de Arbitraje de Inversión. Adelante, Gaby.
Buenos días a todos. Es un gusto el día de hoy tener a la profesora Gabrielle Kaufman-Kohler como nuestra oradora. Ella va a presentar los temas más importantes de la reforma del sistema de arbitraje de inversión y en particular el nuevo proyecto de código de conducta. Creo que justo antes de que ella tome la palabra, voy a hacer una presentación de su currículum. Es obviamente una de las personas más conocidas en el sistema de arbitraje de inversión. Funge en muchos arbitrajes de inversión, particularmente como presidente. Pero antes de eso, me gustaría que nuestro presidente de ICC México nos diera unas palabras de bienvenida. Klaus, si nos haces el honor, por favor.
Sí, muchas gracias, Gabriela. Realmente es un honor el poder dar un mensaje en esta reunión del Comité de Inversión que preside Gabriela. Me da un gusto que mi presidencia de la Comisión de Arbitraje tenemos la idea de crear este comité que ha funcionado de maravilla y que ha traído, Gabriela, realmente expositores extraordinarios, y hoy no es la excepción con la invitación de Gabrielle Kaufman-Kohler, que nos hablará sobre highlights on the Code of Conduct for Adjudicators and ICS Reform, que es un tema de la mayor trascendencia en el arbitraje de inversión. Gabrielle, pues yo la conozco desde hace muchos años, he tenido la oportunidad de estar con ella, hemos sido coárbitros. Ella presidió el famoso arbitraje de Metaltec contra Uzbekistán, que fue un asunto que ha sido muy importante en el arbitraje de inversión en temas de corrupción. También litigado ante ella en tribunales que ha presidido, y sobre todo pues tuvimos el gran gusto conjuntamente con Alejandro Garrio, presidente del Comité de la Comisión de Arbitraje, el haber organizado el muy célebre congreso en la Ciudad de México en el 2018, cuando Gabrielle Kaufman-Kohler era la presidenta de ICA. Entonces creo que fue una experiencia fantástica. Creo que Gabrielle, bueno, ya Gaby, tú hablarás con más detalle de su currículum, pero es una amiga, habla perfectamente español, porque me consta que ha presidido arbitrajes en español. Sé que voy a hablar en inglés, es un tema, es un código de conducta que se redactó en inglés y creo que es lo conveniente, pero creo que el tema es de la mayor trascendencia. Creo que el tema de la mayor transparencia en arbitraje e inversión, las obligaciones de revelación que han sido muy importantes, ha habido críticas al sistema de arbitraje e inversión y creo que se están corrigiendo muchos temas que se criticaban en este sistema de adjudicación, y creo que es positivo. También, sin embargo, también hay temas preocupantes. A mí creo que la obligación de los árbitros de revelar siempre es fundamental. Es importante que revelen los conflictos de interés, pero también me parece que una sobre-revelación puede ser preocupante cuando yo veo temas como el revelar todos los artículos que uno haya escrito, artículos académicos. Yo sé que hay profesores que llevan una lista muy ordenada de todo lo que han escrito. No es mi caso. También en un caso reciente, el que yo fui propuesto como presidente de un tribunal de un arbitraje de inversión, me pedían todos los contactos que hubiera tenido yo y los abogados de mi despacho y los ex colaboradores de mi despacho con los abogados de las partes en ese arbitraje, o bueno, de la contraparte de una de las partes que participaban en ese arbitraje, y realmente para mí hubiera sido imposible. Yo tampoco no tengo un récord de las conferencias en las que participo. Ciertamente, cuando son despachos internacionales importantes, pues que participan en muchos casos, es prácticamente imposible ver un récord de los contactos que haya tenido uno con los abogados de una parte, y sobre todo en el medio académico, en el que nos vemos las mismas personas en muchos lugares del mundo todos los años, muchas veces. Pero, en fin, creo que Gaby ha escogido un tema fantástico y realmente es un honor y un orgullo, Gabriel, tenerte hoy en el Comité de Arbitraje e Inversión aquí en México, y es una de las ventajas que nos ha traído la pandemia de usar la tecnología en forma remota. Me imagino que tú estás en Suiza, pero poderte tener en nuestra sesión el día de hoy es un gran privilegio. Muchas gracias y, bueno, bienvenida aquí a nuestro Comité de Inversión en México, y espero que todos vamos a aprender mucho de tus conocimientos. Muchas gracias.
Muchísimas gracias, Klaus. Y ahora le cedo la palabra a Alejandro Garrio como en su calidad de presidente de la Comisión de Arbitraje de México, también para que nos dirija unas palabras. Muchas gracias, Alejandro.
Muchas gracias, Gaby. Pues me uno al beneplácito que ha manifestado Klaus sobre la presencia de Gabriel en esta reunión. E igualmente quiero agradecerle a Klaus, que siempre ha sido pues de casa en esta comisión de arbitraje, pero ahora en su función de presidente de la ICC México, creo que nos honra con su presencia. La cercanía que siempre hemos tenido con él, pues no debe de dejar pasar el que en su calidad de presidente de ICC México esté tan cerca de nosotros, como estoy seguro de que seguirá siendo muy cercano a esta comisión de arbitraje en su nuevo carácter. Yo creo que lo que mencionó Klaus es extraordinariamente importante, pero además de eso, en esta época en la que el tema del TEMEC está absolutamente en la mesa, nos ha dado mucho gusto su aprobación. Creo que estamos satisfechos de la reunión que se tuvo ayer. Ya como mencionaba Bernardo, a quien veo aquí que nos está acompañando, teníamos grandes temores de esa reunión con el presidente de Estados Unidos, y creo que salió mejor de lo esperado. Independientemente de las ramificaciones que pueda tener, pienso que salió mejor de lo esperado. Pero el hecho es de que nosotros tenemos que analizar el tema de la solución de controversias en materia de inversión dentro del TEMEC. Y independientemente del tema tan importante que nos va a platicar Gabriel, yo creo que hay que ver qué es lo que tenemos en el TEMEC en relación con arbitraje de inversión. Gabriel, como experta que es, tal vez nos podría en un momento dado platicar sobre cuál va a ser el impacto de ese agotamiento de la instancia nacional que se prevé en el TEMEC como una regla general para los inversionistas. El hecho de que el inversionista extranjero, antes de presentar una reclamación ante México, tenga como norma general que acudir a los tribunales mexicanos, pues es algo que es totalmente novedoso. Igualmente, creo yo que tendremos nosotros que vivir con el hecho de que ya no podrán reclamarse cuestiones tan importantes como lo que era la expropiación indirecta, o como que es la violación al trato justo y equitativo. En fin, son temas que verdaderamente nos inquietan. Ya Bernardo, en nuestra reunión del próximo 4 de agosto, nos llevará por ese difícil camino de lo que son las novedades del TEMEC en relación con el tema de arbitraje de inversión. Pero en el tema concreto del que ahora nos platicará Gabriel, yo creo que hay muchas inquietudes que se han derivado y no son nuevas para el arbitraje comercial y que ahora lo estamos viendo que son preocupaciones para el arbitraje de inversión. Yo creo que el tema del árbitro de cabecera, como le llamamos, las designaciones repetidas para los árbitros, son algo de lo que nos platicará Gabriel sobre cómo se piensa resolver. La cuestión que ayer veíamos en la Comisión de Arbitraje de ICC, que fue un éxito, más de 600 gentes comparecieron a la reunión de Zoom de la Comisión de Arbitraje, lo cual demuestra una vez más la importancia de la tecnología en las reuniones modernas, pero se platicaba mucho del conflicto de intereses con los third party funders, con los fondeadores de los arbitrajes en la inversión, y cómo ven los estados, los gobiernos, el que pueda haber conflicto de intereses con esos fondeadores. El tema, evidentemente, que ya está en nuestro TEMEC del llamado double hatting. Ya nuestro TEMEC expresamente lo regula y menciona que no se podrá en un momento dado ser árbitro y ser abogado de parte en una circunstancia de tratado de inversión. Yo estoy seguro que Gabriel nos llevará a explicar cómo es esta cuestión, pero ya lo tenemos, independientemente de un código de conducta, en nuestro TEMEC. Temas tan importantes que ocurren en los códigos de conducta, cómo se llevará a cabo la aplicación o las sanciones de esos códigos de conducta. Yo creo que el tema elegido por Gaby Álvarez es extraordinario y me uno al agradecimiento que ha hecho Klaus y Gaby a Gabriel por su presencia, por la amistad que le ha demostrado a México, a esta comisión de arbitraje y a muchos de nosotros. 1.000.000 de gracias y Gaby, te devuelvo el micrófono para que hagas la presentación de Gabriel Kaufman.
Muchas gracias, Alejandro. Sí, bueno, la verdad que presentar a Gabriel es difícil porque de leer su nota curricular podría pasar varios minutos porque tiene una larga carrera en arbitraje internacional, pero bastaría decir que fue presidenta y ahora es presidenta honoraria de ICA. Practica obviamente el arbitraje internacional, comercial, de inversiones y de deporte. Ha actuado en más de 220 arbitrajes internacionales, principalmente como árbitro y en muchos de sus casos como presidente de tribunal, y bajo una multitud de reglas de arbitraje, en los cuales se incluye obviamente las reglas del CIADI y de UNCITRAL y de las más importantes reglamentos de arbitraje del mundo. Y es una de las árbitros ranqueadas regularmente por todos los, digamos, compañías que ranquean a árbitros tanto en el tema de arbitraje, inversión como arbitraje en general. Un estudio sobre arbitraje e inversión que se publicó en 2016 concluyó que era el árbitro que mayor influencia tenía a nivel mundial en el sistema. Y teniendo esa influencia a nivel mundial, creo que es muy importante en un tema pues que ha causado mucha polémica, escuchar cómo se dio y cómo se está dando primero la reforma del sistema de arbitraje e inversión y en particular que nos hable un poco del proyecto de código de conducta para árbitros. Y antes de cederle la palabra, me gustaría mencionar brevemente una decisión reciente que está muy ligada a dos temas que son particularmente controvertidos o que han causado controversia. Y quiero referirme brevemente a la decisión del Comité de Anulación en el caso de Acer contra España. Esta es la primera decisión de anulación que anula un laudo con base en una incorrecta constitución del tribunal y un quebrantamiento grave de una norma esencial de procedimiento. Y la base esencial fue la falta de revelación por parte de un árbitro de una relación profesional de larga data con el experto y la firma de expertos de los demandantes. Fue la obligación de revelación digamos, de la relación entre el experto y la firma de expertos y su firma y él mismo, y los hechos que se revelaron o que salieron a la luz una vez emitido el tribunal, emitido el laudo, que el comité consideró demostraban una apariencia de imparcialidad. Y como consecuencia de eso, concluyó que el derecho de una parte, siendo el derecho de ambas partes de tener un tribunal imparcial, una regla fundamental de procedimiento, se había quebrantado esa norma y por lo tanto se ameritaba que el laudo fuese anulado por completo. Un punto a recalcar es que el comité consideró que España había perdido el derecho a un laudo diferente, es decir, a un resultado diferente, porque la falta de revelación pudo afectar las deliberaciones del tribunal y en particular el análisis respecto a la compensación. Y en este punto el comité de anulación consideró o hizo hincapié en el hecho de que el tribunal había adoptado como base por completo de su análisis el informe de expertos de los demandantes y que como guardianes de la integridad del sistema CIADI se tenía que anular el laudo en su totalidad. ¿Y por qué es relevante para nuestra discusión? Es porque hizo hincapié en dos temas que aborda el Código de Conducta, la importancia de la obligación de revelación, incluida en el artículo 5 del Código, que su inciso 12 expresamente incluye relaciones con expertos de una parte, y el artículo 6, que aborda los roles múltiples de los árbitros. Y esto es dos de los temas que sin duda va a abordar Gabriel y a la cual le cedo la palabra. Muchas gracias, Gabriel.
Sí, voy a empezar en español, después pasaré al inglés. Agradezco la invitación para participar en este webinar del Comité de Arbitraje de Inversión de México y especialmente gracias a ti, Gabriela, y también a Laura, a Klaus y a Alejandro. Me da mucho gusto estar esta mañana en la Ciudad de México, aunque sea solo en pantalla. Tengo, y Klaus lo recordaba hace un momento, tengo excelentes recuerdos de mi última estancia en México con la ICA que presidía en este momento. Habíamos organizado un congreso con la ICC México con mucho éxito. Con la crisis sanitaria los tiempos han cambiado y no se viaja en este momento, pero espero que todos mis amigos mexicanos y todos los que participan están de buena salud. y que podré volver a México en persona en un tiempo no demasiado lejano. Ahora voy a pasar al inglés, si le conviene a todos, para abordar el tema del día, que es el código de conducta de los árbitros, que es un borrador de código en este momento. No sé, Gabriela, ¿quieres hacer preguntas y yo yo contesto, o cómo quieres proceder?
Sí, creo que para hacer esto mucho más dinámico, lo que vamos a hacer es que Analía González y Carlos Béjar, que son los vicepresidentes del Comité de Arbitraje e Inversión, van a hacer ciertas preguntas a Gabriel sobre los temas que mencionamos. Y obviamente, después de esta dinámica, cualquier persona que nos están acompañando, que tenga una pregunta adicional, una duda, les ruego los vayan mandando ya sea por el chat o bien levanten su mano virtual y con mucho gusto les damos la palabra para que participen. Entonces, adelante, Analía, por favor.
Ok, muy buenos días, Gabriel. Buenos días a todos. Muchas gracias por acompañarnos. Es un honor tenerte aquí con nosotros. Y bueno, de acuerdo a lo acordado, so we're going to switch to English now. And maybe before addressing the highlights of the code of conduct, could you please provide us with an overview of what you consider the main proposed reforms to the ISDS mechanism that are currently being discussed?
Yes, sure. Of course, the main forum for reforms is Working Group 3 of UNCITRAL that has started now. Over 2 years ago was its reform process. But when we say this, we should not forget that this is not the only initiative. There's also the ICSID amendment of the rules that is ongoing. The ICSID convention itself, as you know, cannot be changed, but the rules can be changed. And importantly, which is sometimes forgotten, the states have already implemented reforms in recent treaties, reforms of transparency, reforms even on conduct of arbitrators, reforms about the body that does resolve disputes. So it is a wider context, but obviously it's the main action is on the floor of UNCITRAL. Now, having said that, if I look at the UNCITRAL process, the process was organized in 3 steps, as you probably know. The first one was to see whether there were criticisms about investment arbitration. And the second one was to say, well, if there are criticisms, then is it desirable to make changes? And these 2 are finalized, and now we're in the third step, which is the elaboration of solutions. It was very striking to me to listen for 2 weeks to delegations of states, and the room was always packed, much more than what I was used to at UNCITRAL Working Group 2 on arbitration processes. The room was packed, was high-level government officials of 80 up to 100 countries. So this showed the extreme interest of states for this reform process. It also showed that this was a highly political issue, which made it different from other issues in commercial arbitration, for instance, where matters are more technical, and there's more input from arbitration experts. This time it's the governments having taken over. It doesn't mean they have no experts, but they do lead the process. And during this 2 weeks devoted to criticisms, there was just criticism from morning to evening for 2 weeks. And I was sitting there, and maybe my colleague arbitrators too, and saying, well, actually, they're probably right. We have thought we were doing our best, but then maybe it's not that good, and it has to be improved. And obviously, the arbitration community has then taken this criticism somehow personally. Obviously, that is not what it is. It is simply a system that has probably had its advantages for a number of years, and the world has changed, and the needs are different now, and the states which have created the system, sometimes you have to remind them, they have created the system, can change it, and can change it anytime, and can completely eliminate it if they wish. And you have seen with Atemek how the changes have been effected. So that made me think very hard about the need to make the reforms. And obviously the conclusion of the working group 3 was that the reforms needed to be implemented. Now, the range of reforms that is being discussed is extremely broad. And I like to think of them like, on the one hand, you have light reforms. And what I call light reforms are just improvements of what we have today. And that can go to trying to take measures to alleviate cost concerns, security for costs, rules on third-party funding, rules on allocation of costs, trying to take some measures about improving duration, that the excessive duration was also a concern. Then one concern that has been voiced a lot generally about investment arbitration was, of course, transparency, but that has been fixed by the transparency rules in the Mauritius Convention, so that now becomes a matter for implementation and political will to implement. It's not anymore an issue of drafting rules. There is the concern of legitimacy, that focuses on the person of the arbitrators, who are private individuals who rule on matters of public policy that involve states, can have high stakes for populations. That can be dealt with by trying to improve the selection method of arbitrators. So these are all what I call rather light measures, because they take the system as it is. They do not change it, they modify it. And then there is what I call the heavy reforms, and the heavy reforms is creating a multilateral investment court. That would be, that there are many models of international courts. Some are more fortunate in their structure and governance than others, but there are examples of what to replicate and what not to replicate. That would, of course, do away mainly with the issue of consistency, because the lack of consistency has been one of the most important criticisms. And it's true today that on many issues that are recurrent issues, recurrent across treaties, recurrent across different fact patterns, you have different awards with different views. And that, of course, is not good for a system, because a system that produces conflicting results in the end loses the trust of its users and discredits itself. And that is probably in part what has happened, because some users, the states, have somehow are now challenging the system. So consistency would certainly be resolved by a multilateral court. what would probably be resolved as well is most of the issues with respect to impartiality, independence, the way arbitrators are, I shouldn't say arbitrators, the way dispute resolvers or adjudicators, if you prefer, could be chosen. Now that, of course, at the same time raises other issues. Who will be a judge on this court? How will these judges be selected? These are difficult issues, and but there's a lot of research now about composition of international courts, and there's some good examples and less good examples from which lessons can be drawn. Between this light and heavy reforms, there is one intermediary or medium reform, which is the creation of an appellate mechanism. So that the idea there is that you create a body that would be a permanent body that you place on top of the existing system, and it could have competence over all different treaties and probably also different dispute settlement institutions, and it would have jurisdiction. I mean, this all needs to be worked out in terms of treaty technique and rule technique, but it can all be done. Obviously, it creates difficulties with respect to national law, because in national law, you of course know that 60% of investment arbitration today are exit arbitration. 40 are non-exit arbitration. All the non-exit arbitrations are subject to national law, like any commercial arbitration, and so they're subject to the jurisdiction of the local courts. And so the local court, there is annulment before the local courts. Now, would you have an arbitral award and then an appellate decision and then an annulment? Probably not. You would have to merge annulment and appeal. That means you would have to change the national law on annulment. All of these issues need to be considered, but I sense that a number of states which are not ready to go to a court or dissatisfied with the present system would be interested in an appellate mechanism. We are now at the beginning of stage 3 of the elaboration of the solutions. And what has been done is just taken certain solutions and discussed them, but in a very summary fashion for the time being. And then we were cut off by the pandemic, and it is unclear how the works will go on. It is in particular difficult because UNCITRAL uses to work on a consensus basis. So you take decisions by consensus. You practically never vote, except one time there has been a vote in UNCITRAL, and that was to vote for the chair of Working Group 3 on the ISDS reform, which is also a very strong signal of how politically controversial these issues are. Anyway, these are very difficult questions that the Working Group 3 has to make choices on. Reaching a consensus by Zoom is difficult because you need consultation breaks, you need coffee breaks, you need informal discussions among delegations. Now, when will people be back together in a room? We don't know. So all these issues have been quite surprising in the way they impacted the works, and I do hope, and there are of course states who are less enthusiastic about certain reforms, who are not eager to resume the works and find solutions to advance nevertheless. So this is about where the reform stands. I apologize if it was a little too long, but hopefully it gives the framework.
Thank you, Gabriel. And as you just described, this has been a very long process that seems close to be at an advanced stage. Do you think that the states and the investors are ready to welcome such a big and challenging reform with the heavy and the light and the intermediate aspects that you just mentioned?
The investors, I don't know, because the investors are not very present in these debates. There are some observers, there are many observers in Working Group 3 who represent more business interests, but observers don't get much to speak. I mean, they get the floor, but not that much because the state delegations want to speak on every topic. And they're not organized like states to put forward their views. So it is difficult to know what investors really would like and whether it's important to them or not. I mean, some tell me, you know, as long as the tax treatment and the other investment framework conditions are good, I'm fine, and arbitration is much less a concern. I don't know that. Now states, of course, states, we know much more about what states think. They make oral submissions, they make written submissions to UNCITRAL. Of the issues that investor arbitration can rule on. And that is also a way of showing we're not that happy with what these investment arbitrators do. And we want to keep more freedom for state regulation. So the states certainly want to change. Now, it is also clear that they probably don't all want the same things. It was very interesting to see everyone aligned to say we have to change and we criticize the system. But then the difficulty comes when you start discussing actual changes, and there are significant differences between states who only, there has been terminology that has emerged in the debates. The ones that want just what I call light are called incrementalists, because they want to increment to the existing system. And the other are called structuralists. And the structuralists want to make, or systemic, want to make changes to the system that is mainly court, but also appellate mechanism. So there's a clear tension between the incrementalists and the structuralists. And in between, there's many who are not completely clear where they stand. They may favor some incremental and some structural, but it will be difficult to get to consensus. Now, the plan, because of that, if I can add this before I give you the floor back, Nadia, the plan is that to work out a menu of options and elaborate these options so that states can then choose within the menu what they want to implement for their own treaties, for their own arbitrations. So that is the way around the fact that not that there will not be unanimity, there will not be consensus. Consensus is less than unanimity, but it's quite a strong majority. Will probably not be reached with respect to specific proposals for reform. There's one, though, that might get consensus and has already been discussed, is the creation of an advisory center to assist least or less developed countries in investment arbitration matters. And that is now under examination by a research center that will make proposals on how to frame this. But that is just a relatively small part. It's inspired by the WTO Advisory Center.
Thank you.
So to summarize, the states want to change. They probably, among the changes, are not have different views.
Thank you, Gabriel. And you have already mentioned some of the critiques that the ISDS system has received. Some of them are the issue of the double hatting, or the arbitrators that also sit as counsel or as experts, or arbitrators that are appointed several times by the same party. These issues have been addressed both by ICSID and Untittled, as you have described. Do you think that it is important to have a code of conduct for adjudicators? And if so, do you consider that a code of conduct would represent a solution for all the issues that have been found problematic?
Well, there is no scarcity of rules and norms on conduct of arbitrators. If you pause a little, you know that there are treaties with rules on arbitrator conduct. Some even have annexes with codes of conduct. These are recent treaties, of course. You have national arbitration laws with rules on what arbitrators have to do, and they will apply in 40% of the investment cases. You have case law by national courts. You have, of course, with respect to ICSID, you also have certain rules in the ICSID convention, certain rules in the ICSID arbitration rules. So you have annulment committee jurisprudence. Then you have many institutional arbitration rules that have rules. Let's take just the ICC rules. There's a disclosure requirement, there are independence requirements, there are efficiency requirements. All this is covered. Same thing in the UNCITRAL arbitration rules, the last version. Then you have a vast body of soft law. Think of the IBA guidelines on conflicts of interest, extremely detailed on what you have to disclose. You have many codes of conduct by organizations. You have codes of conduct of international courts, of course. You have codes of conduct of national organizations. So there's lots of rules out there. So the question is, does it make sense to have one more code? And what I can see as the reason for this code that makes it worse working on it is that it would provide uniformity in a sense of expectations vis-a-vis investment arbitrators. At the same time, we should not forget that in every case where an issue arises, we will have to ask ourselves, what is the applicable law? You may have a jurisprudence at the seat of the arbitration that is different from what the the code of conduct provides. Think of Mexico. I have not checked, but I'm sure you all notice there are extensive disclosure requirements in this code. Now, would a Mexican court that has to rule on this, on annulment proceedings, for instance, apply these extensive requirements, or would it rather apply its national law and its own jurisprudence that I presume, because it would be the same in my country, would be less demanding? These are issues that will have to be faced if this code is implemented. It all depends then how it is implemented. If it becomes part of a treaty, then it has treaty status and would prevail over national law. If it becomes part of arbitration rules, it will have a different status because it would more have a status like a contract between the parties. So all of these interactions between the code and other norms will have to be considered. I don't think it takes away the uniformity advantage to have a transnational practices for investment arbitrators.
Thank you, Gabriela. Carlos will take the floor for the next 3 questions.
Thank you. Good morning, Gabriel. I have some questions that were given to us, and I think it represents what many people have on their minds. They claim that some recently concluded investment treaties contain a code of conduct for ISDS tribunal members, which include concrete steps to determine whether a conflict of interest could arise or has arisen, and also standards of conduct for ISDS tribunal members, like the disclosure of obligations and obligations of confidentiality. However, these code of conducts do not provide for sanctions. Some people think that they are necessary, other than the sanction or the right of either party to demand replacement of the arbitrator or adjudicator. Do you consider, as some people do, that a code of conduct should also contain other type of sanctions? Or do you think it will be enough sanction the consequences to the prestige of an arbitrator for being replaced?
So we should not forget, and when I discussed and commented on the draft code, I was surprised that the academics who worked on this didn't really take into account that there are already norms, right? It's the same point I made before. So obviously there are sanctions existing now. There's disqualification, there is annulment, non-enforcement. The ISER case that Gabriela mentioned at the beginning shows it well, that there are existing sanctions. This decision has been made, although there is no code of conduct. And that is something maybe I should mention at this stage, which I have not yet. This code of conduct is entitled for adjudicators in investment arbitration, in investment cases. So adjudicators are meant to target arbitrators and members of a permanent body like a multilateral investment court or an appellate mechanism. And it's one of the issues with this code. The issues are very different, are in my view quite different when you speak of the independence of impartiality of judges and the independence impartiality of arbitrators. For arbitrators, what is really important is their individual independence, which can be threatened by the fact they have connections, they have all kinds of activities, whereas a judge especially if he's a full-time judge, would not have these connections, would not have these other activities. So, and the judge is subject to disciplinary power and disciplinary sanctions of his court. So the disciplinary power of for judges is one of the sanctions for adjudicators. The market forces, Carlos, as you mentioned, of course, are also not a legal sanction, but to me, a very powerful sanction because arbitrators live from their reputation. And if their reputation is tainted, that is a major concern to them. Now, should you have other sanctions, and there are discussions about this, the discussion at the in Working Group 3 on this, states were quite vocal. They want to, I would even say it sounded a little bit like want to punish these guys. Now, they want sanctions. But at the same time, there were no concrete proposals. There are not that many possibilities when you have considered disqualification, removal, annulment, non-enforcement. You could think of disqualification and return of fees that you've earned in this arbitration. That might be one possibility. There's a Spanish case that has implemented that, so that was somehow was not damages, but there was just return of the fees. You could have, people have also spoken of naming and shaming. You could have a website where you have a list of bad arbitrators. All of this has to be considered. It's not that easy to implement, and there's one possibility as well, of course, is that has not been suggested, but of course there are places where there is immunity of arbitrators, and there's others. ICSID is one, certain national laws are others, but there are also national laws where there's no immunity of arbitrators or only limited immunity. And that could, of course, open the way to civil liability and damages. So that is what I can say about sanctions. It's certainly a discussion that will need to continue. There are no sanctions so far in the draft of the Code of Conduct.
Thank you. Another question, Gaby already provided us with a summary of the ICER versus Spain case recently published award, and I would like to hear from you if you could share with us your view on this matter. I think it's going to be, and it's extremely controversial. So, but do you think that a professional relationship, even if long-standing and undisclosed, should give rise to an annulment without the analysis or specific analysis of how the disclosure might have indeed affected the alleged treaty violations?
I read ICER a little bit differently from Gabriela, or at least from the way I understood her summarizing it. But of course, she has appeared in this case, and so she knows it much better than I do, and I may not read it correctly. I have understood that the annulment committee thought that there was an appearance of bias resulting from the relationship. And that, in my mind, was sufficient, at least that's what I understand, to disqualify Stanimir Alexandrov. Now, and then in addition, there comes the discussion on the lack of disclosure. But had they concluded that the relationship, so it's difficult to separate the two. The duty to disclose is broader in terms of scope of the facts that you have to disclose than the scope of the facts that are relevant for disqualification. So you could think of a situation where you have not disclosed something that would not give rise to disqualification, and there are national cases, especially in the US, where the very fact of the breach of the duty to disclose was in and of itself a reason for disqualification. So that seems to me to go very far. Now, to what extent do you need to look at the influence on the award of the a situation that is being challenged as giving rise to bias? That I find a very difficult question, because if you think less in terms of individual case, but if you think in terms of the system must be credible for users to have trust. And if there are decisions given that are tainted by an appearance of bias of one arbitrator, you could say that the system itself is affected by that, and so you would not look at the individual decision. You could also say it's a waste, and now you have to start it all over again, and you should rather make sure that this special situation had no impact on the outcome. But how do you ascertain that? That is a very difficult question too, because you cannot look into the head of an arbitrator, and you cannot look into the deliberations, and you cannot look in the heads of the other arbitrators. So this whole dynamic escapes any inquiry. So that I find difficult, and that's why appearance of bias is the test. But it will have to be discussed further, certainly.
Correct. Thank you very much. And one last question in this set of questions. You already made reference to the different local annulment standards that would impact these code of conduct requirements if they were proceeding to annulment in local courts. I think you mentioned that. Should a code of conduct then take into account, you think, the cultural differences between arbitrators? How do you address situations where certain conducts might be permissible in some jurisdictions but not in others?
Yeah, it's a very difficult question, because, and you will say, I always say it's a difficult question when I don't have a clear-cut answer, but it is obvious in my experience that there are different standards among arbitrators. For instance, what does the behavior of a co-arbitrator may be culturally influenced. And should you take this into account? Well, if you want to be consistent and you want to have a transnational uniform code that applies to all investment dispute settlement, then the question is no, because that's precisely what you want to avoid. You want everyone to have the same standards. Now, that doesn't entirely answer the question, because I'm not certain that this will prevail in national courts, and will the national court not think that, for instance, this relationship was really not something, it's completely trivial, this is really not something that you should have disclosed. That may well happen, yes. But I think the idea of this code is precisely that everyone should be on the same page.
Correct. Well, I'll now give the floor to Analia for another group of questions, if you don't mind.
That's fine, yes.
Thank you, Carlos. Thank you, Gabriel. So you have already mentioned that one of the strongest criticism that the system received is the perception of lack of independence and impartiality. What should be the degree of detail that should be provided in a code of conduct on the requirements of independence and impartiality?
Well, it's very difficult to be very detailed about independence and impartiality because these are abstract concepts, right? I used to define impartiality as independence of mind, and independence just factual independence, no connections with the parties. But having said that, what is independence of mind? What is impartiality? Is very difficult to articulate. I was at the first working group that elaborated the IBA guidelines on conflicts. And there, the only way we found to kind of illustrate this was to do the lists of examples. But that list is not exhaustive, and on some instances, it may be arguable, and there is this overall caveat that everything depends on the actual circumstances. And so it is quite difficult to, in my mind, to give a very specific description of the concepts. Now, there are certain rules that can be set because a double hatting ban, for instance, is an example. Because that may impact impartiality, and then you could make a policy choice that to protect impartiality, you impose a ban. That could be a rules. You could have similar rules on repeat appointments. But beyond that, I find it somewhat difficult to be very specific. I mean, the code has some description, but then it all depends what you read into the words.
And thank you, Gabriela. And on the issue of double hatting, do you consider that a code of conduct should ban double hatting, or should it regulate the practice? And also, would a prohibition on double hatting infringe on the party's right of appointment? And a further question, would it further limit first-time appointment of potential young arbitrators who financially still depend on their law firm jobs and do not have the freedom to act exclusively as arbitrators?
If I forget one of your sub-questions, you will tell me at the end, right? Well, there is a rule on double hatting in the draft code that is extremely timid, I would say. Let me find it so I can read it to you. It says, and the code proceeds with brackets in that signal alternatives. So it says, adjudicators shall, and one alternative is refrain from acting, and the other is disclose that they act as counsel, expert, witness, judge, agent, or in any other relevant role at the same time as they are acting on matters that involve the same parties, the same facts, or the same treaties. And then you have brackets for the same facts, and you have brackets for the same treaty. Now, but you don't have brackets for the same parties, which is strange, because obviously if you act for the same, in a matter that involves the same parties, you would have disclosed that under the normal disclosure requirements. So if it's just a disclosure, that will not help. That is not what is meant. What is aimed at in avoidance of double hatting, or if you prefer multiple roles, is really, I think, issue conflicts and linked to that the appearance of bias. And that comes up because in investment arbitration, as you know, you have recurrent issues. And you have recurrent issues. What does fair and equitable mean? well, you have this in practically every treaty, right? And that is not fact. It can be fact-driven, but the legal definition is not fact-driven. It is independent of the actual parties. It is independent of the actual treaty. So if you want to have a rule, you cannot have all these brackets that limit it to same parties, same treaty, same facts. And the suspicion, of course, is that in one role, you would try to put forward, you would act in a way that influences the outcome in one of your other roles. And in other ways, you would act in one role, especially in the arbitrator role, but that's the one we're concerned about, in a manner that is influenced by considerations other than the record of the case that is before you. So that probably leads to if you take this seriously and you consider that this can really give rise to bias, then probably you need to have a ban like you have it in the USMCA, like you have it in the CPTPP, you have it in the Dutch Model Act. I was a strong proponent of the ban against multiple roles in sports arbitration, where this has come up over 20 years ago, because you have the same pattern there of the same rules appearing in every regulation of sports governing bodies. And so the same issues come up over and over again. And so I did introduce, and that was at the Sydney Games in 2020, a rule against double hatting that has become then the rule in sports arbitration. You're either an arbitrator or your counsel before the Court of Arbitration for Sports. You cannot be both. Now there is, when I say that if you're serious about the risk of bias, you have to take this view. There's one objection, and you mentioned it, Analia. There's one objection that does trouble me, and that is that it creates an entry barrier for younger practitioners. And of course, it plays against the renewal of the arbitrator pool. It plays at the same time against diversity, against age diversity, obviously, but also against regional and gender diversity. And we know that the lack of diversity is also one of the criticisms of investment arbitration that needs to be taken seriously. And so we should try to find solutions that improve diversity. So I don't have the answer to this, but I thought that although it's conceptually not rigorous, but nevertheless, there may be a way of limiting the double hatting, the multiple roles to a number of a limited number of cases and a limited number of years. And that would then that would mean that during a certain time period and for a certain number of cases, the multiplicity of roles would be tolerated, because that would allow people to transition from a counsel role to an arbitrator role. And after a while, you would then need to choose, either you pursue an arbitrator career or you pursue a counsel career. But this is not at all in the code as it is before us for the time being.
Thank you, Gabriel. And another important aspect of the reform, as you mentioned, is precisely the issue conflict that you were referring moments ago. The fact that certain issues come over and over again, and arbitrators sometimes need to decide on those issues in several cases. what would be, in your opinion, a good approach by a code of conduct to deal with a potential issue conflict?
Well, the code tries to deal with this essentially through disclosure. And it requires that you disclose, it says, all ISDS, and then you have in bracket, and other international arbitration cases in which the candidate or adjudicator has been or is currently involved as counsel, arbitrator, annulment committee member, expert. So that is, so parties know where you have rendered decisions. And then there's another aspect of the issue conflict that is not other decisions, but opinions voiced differently, for instance, in publications. And then it says you also have to disclose a list of all publications by the adjudicator or candidate. And then you have in brackets, and their relevant public speeches. Now, that, I suppose, I would not give all international arbitration cases, because what you have, your other commercial cases are really not relevant to issue conflicts. You can do all this, and I do it as a matter of course at the beginning of an arbitration. But this is a continuing duty of disclosure, which is fine. But then let's think about, do I have, each time I'm appointed in an exit arbitration and my name is shown on the exit website, do I have to tell this to the parties in my pending arbitrations? If I read this, yes, I would have to. Maybe we could say that what is publicly available on the exit or on the PCA website, the parties can check for themselves. So that is a different issue as to what extent parties have some duty of inquiry, which is not covered in the code either. And then the disclosure of speeches and publications. At the beginning of the arbitration, you could do so, but as Klaus said earlier, he doesn't have a list. And I'm afraid I don't have a list either. And what is a speech today? Is what we're doing now a speech? Or is something you write on a blog a speech? Is a tweet a speech? I don't know. And then, so do I have to write tomorrow in my arbitrations to the parties that I spoke today on a topic of investment arbitration? That seems really excessive. So that these provisions have to be fixed. We should also remember with issue conflict that the position now is that this is not a ground for disqualification if you have made a decision on a given issue, or if you have expressed a scholarly opinion on a given issue, unless there is, quote unquote, something more, which shows that you will not change your mind for one reason or another. And we have one example by a PCA Secretary General decision in case Devas. So issue conflicts can be dealt with certain level of disclosure, but we should not forget that issue conflicts, as a matter of course, should not be a ground for disclosure. It should also not be a ground for disclosure, otherwise it will have a chilling effect on the academic debate, meaning that professors who at the same time are arbitrators will not write anymore. And that, of course, when we right now particularly need research and thinking about these issues.
Thank you, Gabriel. I'll leave the floor to Carlos, who will be asking the next questions. Thank you.
Carlos, before you go ahead, was the next question. I see time is passing, and I really would not want to eat into the question time. So if you want me to be shorter, just say so, right? Or you can even interrupt me. Just feel free.
I think you're providing us with a lot of interesting views that I think everybody welcomes. And if time is running up, I guess we might be a little bit more selective with the questions to go into those that are probably more relevant to the audience. Or if you think that one of these questions is not as relevant, please, I mean, you can also.
I can also say so, yeah.
Sure.
Sure. Sure.
This question is probably an overarching and more philosophical question. So as it touches upon the concept of integrity of adjudicators, and I don't know if that can be translated, or should integrity could be addressed in a code of conduct, and what elements should it cover?
Yes, the code of conduct does address it. I think it's in an article 4, and it states that the arbitrators need to comply with the highest standards of integrity. I just think we don't know what that is. What seems important to me is that an adjudicator should avoid conduct that is not in line with the dignity of the office. That may sound a little presumptuous, but somehow, put more simply, you have to behave, right? You should, and that is an important point that you find in certain treaties. You should not accept gifts or advantages or of any kind in the context when you're exercising from the parties or people close to them when you're exercising arbitrators' duties. So maybe that could be said. Do not act in such a fashion as to affect the integrity of the case. Even, for instance, you cannot comment on a case while it is pending. I would not comment about it either afterwards if I have been an arbitrator, except, of course, to state things that are of public record, but otherwise not, and I would not give an assessment or a judgment. So all of this is part, I think, of integrity, somehow goes without saying for any reasonable person, I would say. But the fact of not accepting gifts, maybe that's something in the context of the anti-corruption fight that might be useful to say expressly.
Thank you. Another practical question. We all probably have been involved in cases where an award has taken more than a year or so to be published or circulated to the parties. I guess the idea of shorter times in arbitration vis-a-vis local courts is probably a myth in certain jurisdictions. Should a code of conduct include requirement of diligence and efficiency, requiring arbitrators to perform their duties truly and expeditiously during the course of the proceedings?
Yes, I think it should, and this draft does. It will not add much in the sense that the existing rules all provide for this, or if they don't specifically provide, like the ICC Convention, it will be provided in the declaration when you accept your appointment. So it will not change the current position. Well, hopefully arbitrators will take this more seriously, and I think arbitrators do understand by now that speed is important. Quality is important too, so it is not that easy. But at the same time, if we want to set uniform rules in a code, then this should certainly be part of it. I don't think it will be controversial.
Okay, This is a little bit long question, but I think the main concept here is the confidentiality that arbitrators and also, I guess, the lawyers participating in a dispute should keep for how long, particularly when they would survive the termination of the proceedings. How do you reconcile this with the requirements of transparency, including the framework set up under UNCITRAL rules on transparency in treaty-based investor-state arbitration and the relevant investment treaty provisions on this matter?
It seems clear, I think, under most applicable legal frameworks that the arbitrators have a duty of confidentiality with respect to any aspect of the case that is not in the public domain. The situation with the parties may be different, but the arbitrators have to respect confidentiality. There's a secrecy of deliberation, of course, that goes that is enhanced confidentiality, but then you also, for all other facts that you have knowledge of as a result of your participation in an arbitration as an arbitrator, you would have a duty of confidentiality unless they are publicly disclosed. And so that explains also the link to the transparency rules. The transparency rules provide that if you operate under these rules, a number of submissions, not the actual exhibits, not the witness statements, expert reports, for instance, would only be available on request, but they could be made available. They would not be publicly available on a website. But essentially, the submissions would be available, and so that would not be covered, I would suggest, by the confidentiality duty. Now, how long does it last? That is something that's missing in this draft code. It only applies to current arbitrators, does not apply to former arbitrators. Obviously, the duty of confidentiality does survive the end of the arbitration, and in my view, it is indefinite.
Thank you. Well, we are already at 9:24 here in Mexico City, and there's 3 more questions from Analia. Maybe you want to address them as you feel, but maybe we should leave some time also for questions from participants. Analia, please.
I'm in your hands. If you want to switch to questions from participants, that's fine.
Thank you very much. These are very short questions. And another important issue is what is related to the qualifications to serve as an arbitrator or adjudicator. And the question is whether qualifications requirements should be part of a conduct. For example, should they include a reference, the code of conduct include a reference to an obligation of continued education or regular training?
There is now in the draft, and indeed mentioned that arbitrators should be competent. I hope that would be an expectation indeed. You could say there's some continuing education. Why not? Why not? Will it really change the present situation? I don't know. I mean, it's part of the problem of the pool being so small, is that parties always choose the same people because they think these are the ones that are competent. So, and you want to broaden the pool. There's many other people competent out there that could be chosen as well. So it's also a little bit the responsibility of the parties.
Okay, and in fact, there is only one more question. Thank you, Gabriel. What should be the consequences of a failure to meet the obligations of a code of conduct?
have we not already discussed this before when we said whether there are sanctions to the failure to comply with the code of conduct? I think the same applies here. Yeah.
Okay, thank you so much, Gabriel. Gabriela, I'm not sure if we should now give the opportunity to the participants to ask questions.
Sure, I think les pedimos a todos que por favor nos comuniquen sus preguntas. Tenemos una que nos comunicó Francisco antes de que tuviese que dejarnos, y creo que podemos aprovechar para plantearla. Él dijo, it was nice to see you. To Gabriel, excellent presentation as always. I will need to leave given a prior commitment. However, I did not want to get to your opinion. He didn't want to miss your opinion on the code of conduct, and he was particularly interested on the topic mentioned by Alejandro Garrio, double hatting. And his question is, may I ask what your opinion is on the following statement? Blanket prohibition on double hatting is overly prohibitive. Thank you in advance. I think you already addressed part of this question in a way, but I don't know whether you want to comment further.
No, I don't think I can say much more than what I said before, in the sense that a blanket prohibition is the rigorous way of dealing with the issues. Now, at the same time, this is real life, and if we continue to have arbitrators that are not members of permanent courts, then we will need to renew the pool of arbitrators. And therefore, as I said before, we have this issue of the barrier. And I heard people say the other day, well, you know, that doesn't matter because there are other possibilities of finding arbitrators. So, but in academia, you would have a few people who could be arbitrators, but I mean, you need not only understand international investment law, you also need to manage a process, and it can be a more and more complex process. In government, there may be very knowledgeable people, but then they have incompatibilities. So there's not that much other, judges will have incompatibilities as well. So there's not that many other places than the bar where you can find arbitrators of the new generation.
Yes, no, I agree that it's not an easy outcome there. And maybe I see that Elsa is coming with a question. I don't see it. Okay, so she says, you spoke that the plan of Group 3 is to give countries a menu of solutions for them to choose from. Does that include the idea of developing a multilateral court? How would that ensure that many countries join in?
Yes, it does include the multilateral court. By the way, Gabriela, I see Bernardo Sepulveda who raises his hand, so he probably wants to say something when I'm done.
Yes.
Yes. Yes, it does include the creation of a multilateral court, and that would be one of the options. How to ensure that many do join, that will be political choices that countries will make. Obviously, the champion of this court is the European Union, which has already implemented it in all of its free trade agreements since for the last few years, and others may join too, but that is difficult to predict at this stage. By the way, if you think about the court, most of the issues that we have discussed this afternoon would not have arisen if we had been speaking of a court. So we have to keep this in mind. There are other issues it's a little bit more complex than that, why a court does make sense. Because I think we're in a world where more and more people, because they have democratic values and more people live in democracies, they trust institutions. And that's just part of the democratic pattern. They do not trust individuals, of course, except, of course, elected individuals. And arbitrators are not elected. Now you will tell me, depending on the system, judges are not elected as well. But the appointment of judges is embedded in a democratic process. And that is not the case for arbitrators. They're just appointed by a party. And that is a part of the issue with the current system. You could change this by having an appointment by an appointing authority, or having a roster, a list of arbitrators that has been pre-screened. All these are solutions that could be looked into.
Yes. So, Bernardo y luego Alejandro tenemos preguntas. Bernardo, adelante.
Thank you. Thank you very much indeed. Gabriel, a pleasure seeing you again. A pleasure talking to you again. And my congratulations for the publication of your book, Investor State Dispute Settlement and National Courts. I think it will be an extremely relevant reading for all of us. I would wish to learn more about your own views of the viability of a permanent court of arbitration. It has been said by some of our colleagues that the creation of such a tribunal would mean the total destruction of the investment settlement, dispute settlement, as we know it. What would be your own view on the matter? Would you think that it's viable? Would you think that states will want to commit themselves from a political point of view to the establishment of a permanent court? You have already mentioned the fact that in the case of the European Union, they are very sympathetic towards this establishment of a permanent court. But I wonder if other states who are important and relevant in the international system will be amenable to the creation of such a court. What is your own perception on the matter? Thank you, Gabriel.
Bernardo, it's very nice to see you. And of course, you know well how an international court functions, and you can compare the two systems better than anyone here. So destruction of the current system, no, because even if you have a new court, that court will have jurisdiction over treaties that give this option or only provide for this jurisdiction. This would be new treaties, or otherwise you would have states to have to opt in for their earlier treaties into the court mechanism, like under the model of the Mauritius Convention on the transparency rules. Now, but that does not mean that the 3,000 investment treaties that are out there will from one day to the other, and most of them have arbitration, will from one day to the other switch to the system. There will be parallel systems necessarily, even if the court is created. Yeah.
Okay, thank you very much.
Sure.
Alejandro, por favor, adelante.
Thank you, Gabriel, for an impressive comments that you have made. As I mentioned at the beginning, Annex 14D.6 TEMEC mentions that the arbitrators or adjudicators should comply with the guidelines of the IBA on conflict of interest. And it also mentions the rule of double hatting, mentioning that the adjudicators should not act as lawyers or experts or even part witnesses in a pending arbitration. Do you think it's a good idea to include these regulations on the treaty? You mentioned that in the code of conduct, the aspect of sanctions to arbitrators have not been included. But if you include obligations for the arbitrators or adjudicators in the investment treaties, then you have a rule there that if it is violated can, you know, bring a consequence. Is it a good idea to include in the 3,000 investment treaties that you mentioned something like this, or should it be better just to leave it in a code of conduct with a general application which could be interpreted in a different manner by whoever is you know, judging the compliance or non-compliance with such a code of conduct? I would be very much interested in knowing your point of view.
Yes. First, your reference to the IBA guidelines is interesting because the draft code on central exit does not refer to them at all and seems to be more demanding. It is more demanding in terms of disclosure. So some people have criticized this and said, well, why don't you just take over the IBA guidelines? Now, the IBA guidelines is true, have been prepared more with commercial arbitration into investment arbitration. Maybe but they could have given a start. That has not. Now about your broader question about whether that is, it is good to have it in the treaty. Of course, that makes it binding with the result that it will then have to be considered in this qualification proceedings as the obligations are stated in the treaty. If it is in a soft law, or then just a code, but a code that is not binding, then it, as you mentioned, it could then be taken into account or not somehow, depending on the circumstances and the cultural differences, for instance, that we discussed before. Of course, it may be that this code of conduct is then taken as such and made part of a treaty. That is one. That is an option that is not discarded so far. It's not been discussed yet, but it's certainly one of the options. And then we get back to the CEMEX situation where you have the rules that have the force of a treaty. So this will be for the states to decide whether they want to make it a treaty or whether they rather keep it as soft law, like the IBA guidelines currently are.
¿Alguna otra pregunta del público? Bueno,
no tenemos, Gaby.
Okay. I would just mention something that maybe if we have some minutes regarding your comment, Gabriela, at the beginning on the ACER decision. You're right that the committee has like two approaches. First, the approach regarding whether there is an appearance of lack of independence based on the long-standing professional relationship between the expert and the arbitrator. And that was analyzed in the framework of an improper constitution of the tribunal. But then there was the second ground, which was a serious departure from a fundamental rule of procedure. And there, the standard is whether, or how the committee approached it was whether there was, they found there was a fundamental rule of procedure, that it was breached, but then whether it was serious needed to be addressed as to whether that could have affected the award. And that's in that framework that they made the analysis regarding deliberations, that as I think your reading is correct, is similar to the tribunal, that the committee, they found it was very difficult because you cannot get into the minds of the arbitrators and know exactly what the deliberations were conducted and what was the influence of that particular arbitrator in the deliberations. And I think what maybe the insiders or we have is that there was a second ground of annulment, and a second ground of annulment was based on the damages section of the award, which was directly relevant to the expert. And I think the committee had heard at length arguments on how that damages section of the award should also be annulled based on the expert report. And I think that's the reason, and this is more this is the reason why the tribunal entered into that section, into that analysis, and how the expert report was adopted by the committee and had an influence in the outcome, I think, of the decision. But just for clarification, because I think it's important, and it's important because there was this second ground, which was really, really discussed at length.
Thank you. That's interesting. It's always interesting to understand how decisions are what they are, not just on the literal reading of the decision. It seems to me that if there had been a double hatting prohibition in place, then this situation would not have arisen, right? Because if I read the tribunal correctly, it was bothered and it distinguished other cases in this respect by the simultaneity of other arbitrations where the expert was working with the arbitrator and this arbitration.
That's correct. There were at least 2 or 3 arbitrations that were conducted in parallel to this arbitration, and that was unknown to at least Spain and the other 2 arbitrators. And yes, the facts were obviously particularly relevant.
Obviously, this decision has prompted me to set up a process now that I did not have in place systematically. To each time I receive a submission that appends an expert report, I enter the name of the expert firm and the individual expert into my system, and I do search whether I have some connection or possible conflict so that I can disclose it. It's easy, at the beginning of the arbitration, you do not know what the experts are. So this is something that comes only in later, and that is when I find it more difficult not to miss possible disclosures. And that was not something, at least I was doing systematically. I would do it if I would occur to me. And now, I mean, I have systematized this. So the disclosure requirements are quite a burden on arbitrators.
And it's very interesting what you said, because first, this is particularly, and I think the committee was also very clear on this is particularly relevant for arbitrators that do have double hatting roles, right? And that are very active as counsel at the same time. Second, it's also interesting because I had been approached by expert firms to get the decision, although it's published, it's published, but sometimes they seem not to find it. I think it becomes relevant for them too, because although there is in the IBA rules an obligation of disclosure for experts regarding relationships with arbitrators, parties, counsel, what I have found in my experience is that sometimes you have partial disclosures from experts. Now, like they said, we don't have relationship with the parties and their representatives, and they omit the members of the tribunal sometimes, and even counsel, right? We have now to systematically check and ask for disclosure, particularly when you have arbitrators that you know that they do double hatting. And because I suppose now it's going to change, but I know that the views before were that for certain people that this type of relationship was not disclosable, although the code of conduct now does include that relationship. And it included it before the ASER decision came up. So, so it's interesting. The developments are interesting. And I think they are pushed a little bit also because of the situations that have been developing in the investment arbitration field, right?
Seems obvious to me, though, that the fact that the same expert has appeared before you is not something that you should disclose. But I'm not even sure about that, because this expert I've heard many times, right? And other experts I've heard many times as well. Now, do I have to disclose this each time? So far, I had not done it. Or is it only when you have had dealings with this expert in another role that it occurs? I mean, ISER is clearly about the multiple roles, right? It says nothing about the other situation. No. And to me, if I heard the same expert 3 times, 4 times, when I chair a tribunal, that should not create any appearance of bias or any justifiable doubt.
Yes. Yeah, so I don't know if in the meantime there are more questions. Otherwise, if we don't, I think I just want to again say thank you very much for sharing your thoughts on these very important issues to the Mexican community, but we have also people from other parts of the world listening to us, which is great with these virtual webinars, and muchas gracias, Laurita, por la organización, a Carlos y a Analía, y por asistir en esta dinámica. Alejandro, muchas gracias por acompañarnos. Klaus nos tuvo que dejar, pero le agradecemos mucho que haya estado en gran parte de esta sesión. Y yo, pues, de nuevo, muy agradecida a Gabriel, que además tuve el honor de compartir con ella el primer caso que tuvo en el CIADI como presidente de un tribunal. Que fue
hace muchos años.
Sí, no quise decir los años, pero sí, ya fue hace varios años.
Yo lo sé.
Y me da mucho gusto encontrarla ahora en este contexto. Y bueno, obvio, hemos cruzado el camino varias veces en diferentes roles también. Y pues muchas gracias. Y muchas gracias a todos por su asistencia.
Muchas gracias, Gaby. Hasta luego. Muchas gracias. Gracias, Gabriel. Gracias.
A todos.
Gracias.
Hasta luego.
Gracias,
Gracias.
Gabriel, todo lo mejor. Hasta pronto.
Gracias a vosotros también.
Magnífica conferencia.
Gracias.
Gracias. Hasta luego.